then we shall be covering 3 different areas. Spotlight on the law, which will be providing you with some insight into any legal and regulatory updates, changes, anything on the horizon. We'll be looking at some practice, maybe a little bit of a skills update, or some insights on some new skills, and then going to the well for one of our experts who'll be introducing an idea, concept, something to motivate you into your day. Sabina, a little bit of housekeeping, please.
Yes, so any questions, comments, if you just put them in the chat box, and if we are sufficiently efficient, we will have time to address them at the end.
Fantastic, fantastic. Okie dokie. Well, let's get straight into the spotlight on the law. And usually we start with what's happening over there, meaning Ireland, but actually we're going to be kicking off with the UK. So what are the latest developments over here in the mighty United Kingdom?
Well, we'll leave out the mighty part, but anyway, particularly when it comes to rugby. But we'll, I mean, from an Irish perspective, this is interesting, all right, because we've kind of been patting ourselves on the back for leading out on you know, regulatory developments in mediation for a while, but we are being rapidly overtaken. And the latest in the series of interesting developments across the water is the government response to the consultation process on integrating mediation in the civil justice system over there. And this is the kind of outcome of quite an extensive consultation process, which elicited the views of, well, anyone interested really, got a lot of input from mediation bodies, education providers, including ourselves, academic organizations, interest bodies, and various other institutes and institutions, which the government, well, say they took on board, and came up with a report and some well, not so much recommendations, but some stated intentions, if you like.
Okay, so what was the sort of broad outcome from that consultation and the report?
So the broad outcome is that the government committed to, and I suppose I'll just quote, to fully integrate mediation as a key step in the court process for small civil claims valued up to £10,000. So there is now going to be a mediation, I use the word requirement, for anyone bringing a small claim up to £10,000 in value. And beyond that, the government also committed to extending this into higher value claims in due course once the initial rollout is completed. So they do envisage that really the bulk of civil claims will find their way, or will be directed, funneled towards mediation initially. And I think they are probably waiting for the fuller rollout on this to see what the outcome of the Churchill versus Merthyr Tydfil case is, which we talked about last time, and which is listed for hearing in November.
Yeah, the Welsh are dragging that one out.
Absolutely.
So, I mean, I've got a bunch of questions rattling around in my head. I think I read somewhere that it's going to be something like 90,000 referrals in terms of sort of addressable market, a number of claims a year. But 90,000, so that's about 90,000 mediations. How is this going to work in practice then?
Well, I mean, it certainly will look different to the mediation that I did yesterday, put it that way, where we didn't really get beyond the opening exploration until well after lunch. But so this service is going to take the shape of basically an automatic referral to an hours free telephone mediation, And what that effectively means is that each party will get an hour in sort of shuttle format with the mediator to see, can a deal be thrashed out? Now, I mean, telephone mediation sounds somewhat bananas in the age of, video conferencing and AI, and yet is more common than you would think, not least over here, where, as far as I know, the Workplace Relations Commission still work frequently on a telephone mediation basis, and I think possibly the Residential Tenancies Board too. So telephone mediation is more common than you would think. In practice, I often wonder whether telephone literally means the telephone or whether it has been broadened to encompass a Zoom call. So that's something I have yet to find out. But anyway, that's how it's going to work. There are also a number of sanctions available for parties who do not turn up to the mediation appointment, including potential cost sanctions or strikeout of the claim or defence. Though it remains to be seen to what extent these will be used. I suspect there will be a period of leniency initially, where there might be a slightly more encouraging approach rather than a sanction-based approach. But that remains to be seen.
This whole the whole telephone thing is so British, isn't it?
Yeah, well, it's pop them on the telephone, and it's a matter resolved in no time at all.
Well, the PIAB, thank you, Rachel. Also, the Professional Injury Assessment Board also use phone mediation.
I mean, to actually do something accomplish something in an hour, you're going to need certainly a new skill set. Process management being at the top of the list. Okay, you've got 30 seconds for your opening statement, starting now.
Exactly.
Okay, stop the clock. But what's the law that states that a task will fit the amount of time allotted to it?
Well, this is it, and I mean, certainly from I don't know, Rachel, to what extent you've found out about this, but certainly the outcome reports from here actually seem good. The most recent was it the Financial Services Mediation Service? I think they actually had, I might be misremembering this, but I think they had a marginally higher success rate on their telephone mediations.
Yeah, we covered this. We covered this.
Yeah,
in the earlier spotlights, didn't we? Yeah, we've got the numbers.
Yeah, that's right. So it's not just because it doesn't look like the kind of standard type of mediation doesn't necessarily mean it doesn't work.
Yeah.
Because, of course, the reality is, are the claimants and respondents or defendants in these cases going to get much more time in court?
Yeah.
Probably not.
Yeah.
So in fact, they'd probably have a lot of time in court if the district court down here is anything to go by. So
and they'll be waiting ages anyway.
Exactly.
Yeah. So who are going to be providing these 90,000 mediations a year?
Well, as I understand it, initially it will be mediators kind of recruited, trained, and employed by His Majesty, I should say, Courts and Tribunal Service, which is basically kind of an extension of their existing small claims mediation service. But the government has said that once this extends into higher value claims, that they will be contracting mediators in from the private sector. That, which of course brings with it all kinds of questions and considerations around regulation, oversight, training, standards, affiliation to different bodies, and there's already some sort of jostling going on in that respect amongst mediation bodies. So that will be very interesting to see how that is going to work out in practice. That's really what we're all waiting to see over here. We'll let you guys try it out over there before we do the same thing.
I mean, you could work out the economics of it on the back of a fag packet in terms of how many mediators they would need full time, what the cost of that would be, etc., etc. I guess one of the questions will be you know, if you've got parties and it's their first time to have any sort of interaction with the justice system, what's that going to be like? And you know, is that going to be, are they going to have a positive experience? Are they going to have a, you know, how's that going to be managed?
Well, this is the thing. I mean, and this is, I suppose, why this development is significant. I mean, of course, it's significant from the perspective of just the endorsement of mediation as a dispute resolution process. Also, from the perspective of the likely time and cost savings that is driving the initiative. But you know, if you think about it, small claimants, if you want to call them that, or claimants in small claims cases, are probably, you know, the first engagement that most people are likely to have with the justice system. And I have to say, I'm you know, I'm an eternal incurable optimist when it comes to mediation development. So forgive my glass half full perspective to anyone who is a bit more cynical about these things. But I think the value of somebody's first interaction with the justice system being pointed at mediation or a mediation style process more than a court style process is in itself a good thing, because it again, it calibrates the default slightly differently. So when those parties go on possibly to find themselves in a relationship breakdown or a personal injury claim or something more significant, at least mediation will be a concept that they are familiar with. So that is likely to have more of a trickle up effect than, for example, mandating mediation in the commercial court over here is likely to have a trickle down effect, because those litigants are going to be much more sophisticated anyway. You know, really getting mediation in front of the ordinary man and woman on the street is a way that is only going to benefit the process, provided that the information on the process is accurate, effective, comprehensible. So information is the key to all of this. I mean, it's the key to any access to justice issue, and that's a broader question. But you know, we will need to be assured that parties are given accurate, comprehensible information on the mediation process before they enter into it.
Yeah, so you know, if you're being the eternal optimist, you could say, well, it's an expensive PR exercise for the MOJ, but also trying to encourage everyone to experience mediation as early as possible, bring it into the lingua franca of business disputes. And so if I get this right, you've got a claim, you bring the claim, you file that, and then the defense then has to file their defense. What happens next?
Yeah, and my understanding of it is, and again, you'll have to forgive me because I'm not as familiar with England and Wales filing procedures as I would have been in the day with Irish, but my understanding is the claim is filed, the defence is filed, and then both parties are issued with a questionnaire, which sort of is almost a kind of a pre-mediation questionnaire, which is intended to assist them with narrowing the issues and matters like that. So it'd be very interesting to see. I read an interesting blog recently by a mediator who actually had to go through the small claims process to claim fees from a lawyer, which is kind of entertaining. And just the level of frustration she felt with the existing small claims process and court fees and delays and having to travel to a small claims court out of, you know, far away and stuff. It's certainly the perspective she gave on that versus the idea that, you know, you might at least have the option of attempting to solve this over the telephone, you know, at low or no cost from the privacy of your own home is certainly looks attractive.
Yeah.
Particularly to somebody who might be, you know, a business person, might be quite busy, you know, trying to collect in small amounts, because you know, £10,000 is actually not that small an amount of money.
Yeah, for sure.
You know, we're not talking about sort of hundreds of pounds here.
Well,
so
initially it was going to be up to £500.
That's the initial, that's the existing small claim service. Yeah.
But
so
they
it's
were
a big extension.
Yeah. There's been an update recently as well from the Civil Justice Council. Is that right?
Yeah. So just to kind of wrap up on this, is that the other small development, not small development, the other development in the small claims area or in the claims area generally is that the Civil Justice Council, who are also looking at promoting mediation, have written a report on pre-action protocols, which is the stuff you have to do before you can even file a claim. And they have recommended including obligations to engage in ADR, likely mediation, before you actually ever file a claim at all.
Oh, right. So you've got to mediate before you mediate.
Yeah, pretty much. Now they do say that they will draft this recommendation or these suggestions in a way, in such a way as to complement rather than conflict with the HMCTS initiative.
Okay.
But we'll have to see kind of exactly how they do that. Okay. But you know, it's certainly a trend between those developments. You know, you've got the Churchill case. It's quite an interesting space to watch at the moment from a regulatory perspective. You know, and we'll come back at the end of this session briefly to the question of professional regulation of mediators. But
that is the difference between you and I. You can say this is going to be a really interesting space to I could never say those words about regulatory changes.
Yeah, but bear in mind, I when the Mediation Act in Ireland was being passed, I was literally watching proceedings from the Legislative Chamber live on TV. So, you know, I am a nerd of the highest order. So excellent. I wouldn't align yourself to that. But, you know, to focus on more practical things, I'm going to yank the baton out of your hand, Alan, and ask you what is on the docket for skills practice this week.
Well, on the theme of A-level and GCSE results, which have both been in the household this last few weeks, I was reminded of, I'm a bit of a pedant I'm known as a bit of a pedant in my house around questions. And if my kids ask me closed questions, they get, you know, the answers that they deserve. And it's become a bit of a joke. Anyway, my daughter texted me her A-level results. And I was sort of waiting, sort of on, you know, she's been quite sort of stressed out about this. And I get the message, but it comes to me, and I don't have my glasses to hand, right? So I can read her text, but she's taken a photograph of her A-level results page. So there I am trying to zoom in and out, trying to see what the results were. And then all her text was, "What do you think?" But I couldn't see actually her results. So I said, "Well, what do you think?" And I said, "Aren't you pleased?" And I said, "Are you pleased?" And of course, I had to confess that I couldn't actually see what she actually had. But I was kind of reminded of questions and how important questions are. Well, I should have just said, "What were your results? What did you get?" But she was very, very pleased, very happy, and got exactly what she was looking for. But it sort of reminded me a little bit of questions. And I think it's not just something that people in general, especially those that train as mediators, find challenging, but it's one of the things that I found really tough during my early years as a mediator. Was, you know, asking a question and listening to what they were telling me. You know, I would ask a question, you know, it might be an open question, and they start talking, and I've stopped listening, and I'm just going around in my head now thinking of the next question. So I found, it was a combination of listening, but just, really asking useful, productive questions, really, really tough. So.
Yeah, I mean, I think it's something we see a lot in mediation training, mediation education. It's asking questions seems like kind of quite an easy thing to do, but it's actually something that people struggle with more than you would anticipate. And so, what do you think it is that is so difficult for us to really grasp when it comes to learning how to ask really good, productive questions in mediation?
Well, I think there's a number of things going on. I think, from a sort of a skills behavioral perspective, if you've had a career or you've trained as a legal professional, barrister, solicitor, whatever, or a judge, then you are predisposed maybe to doing more talking than listening, or perhaps asking questions that you already know answers to, rather than asking questions that you don't know answers to, which is the flip side, really. So I think there's certainly an element of one's sort of training, education that has an influence. I think there's something inherently kind of human about it as well. It was bank holiday yesterday, and I took the bank holiday off, actually, which was first for me. But I'm in the shed, right? Bank holiday, sort the shed out. I'm looking for tools and things like that. And I thought, I don't want to get in the car now and go and find, buy a tool. I'll just improvise. So I think, you're faced with a problem. Your natural tendency is just to want to solve the problem. But as mediators, we're not there to offer solutions to solve the problem. We're actually there to help the parties solve the problem. And I think those are two fundamentally different practices. So, I think it's counterintuitive actually for us to not solve the problem, which I think might go some way to explain why we maybe are asking questions that are trying to sort of, I don't know, guide somebody down a certain path or a particular direction. So the questions may be a bit more loaded, rather than questions that are genuinely curious. I think the other thing as well, people talk about, having this disposition of being really curious, or an attitude or a mindset of being really curious. I actually think it's not necessarily curiosity that you want to cultivate. I think it's actually being really present, being really in the here and now, not thinking about, what happened yesterday or on your journey in, or other stuff that's going on in your head, or thinking about what you're going to have to do for dinner, or what's the next question that you want to be asking. It's just really being present with that person as they're talking. And I think that is the goal, and that is also the challenge, to sort of embody that presence of mind.
So if we're thinking about particularly, and this is not just for new mediators, because I think particularly that's sort of staying out of, I think I can see where this is going, I'm going to ask a question to just accelerate it and make sure I can get the earlier train home. And particularly if you're maybe in a confined time slot like the HMCTS mediators are going to be, what's a couple of tips or reminders that all of us could draw on, I suppose, to make our questions just that little bit more effective and more curious?
Yeah, well, I guess I'll come to the sort of time pressure piece in a minute, but if I look at some of the patterns that are most common that I observe in people that are learning, and sometimes in myself, it's that pattern of asking an open question immediately followed by a question or two that are closed. So for example, what would you like for dinner? Do you want curry or pizza? Instead of just stopping at what would you like for dinner, then, following up with a couple of close questions. And it's that sort of, having that awareness that that is a pattern, so that you stop right after your open question, and just let it linger for a little while, and I think in conjunction with that is our comfort or discomfort with silence. So I think, we ask a question, we don't get an answer within 3 milliseconds. So we just ask another question, instead of just letting that question just sit there and let the person reflect, ponder, and respond. And I think being comfortable with silence. So I think that's kind of one tactic, having that awareness. I guess the other one that, and it links to presence, I think when you ask a question, is to just really focus on the person and what they're telling you. And you're trying to sort of, find the next question in amongst the story that they're telling you. So I think it's a bit of a sort of a therapeutic practice, where you're sort of asking circular questions. So, you're burrowing deeper and deeper into the issues, or the individual's concerns, by building on what they're telling you. So tell me a bit more about this, or you mentioned that. Could you elaborate on that? So you're getting them to expand, rather than looking down at your sheet at the list of questions that you should be asking at this stage of the mediation process, which is a bit formulaic, but there's a little bit of, oh my God, what could they say next if you went further down this rabbit hole? So there's that, I think, which is another useful practice to develop. And I guess one of my favorites is, and it comes to the, it could be used, when you are in a bit of a rush, and that is sharing your reasoning. So adding a little bit of reasoning seasoning into your questioning. So I'm asking because, so using the because frame. And I think that's helpful, because on the one hand, you're being transparent about why you're asking the questions that you're asking, and you're also sharing what's going on in your head as well, which I think has a multiple benefit, because you are articulating. So you have to find questions. You couldn't say, I'm asking because I have a really great idea that I wish I could share with you. So, using the because frame, I'm asking because, I'm asking this because. And I think sharing your reasoning as well, when you're asking a question or when you're making a statement, helps people to, or stops them sort of second guessing what your motives might be for asking a question.
No, and I don't want to just pick up on what Michael is saying there, that it can be really difficult to be present with one of the talkers when you've also got lawyers and advisors and various other people in the room who are who can also sometimes jump into that useful silence when you don't want them to. And I just wanted to share very briefly an insight, because I had a mediation yesterday that for the first time in a long time didn't involve advisors, because there wasn't a legal outcome as such required. But I noticed that the parties were very well prepared and kind of almost a little bit sort of rehearsed, and had very quick answers to all my questions initially, and stories and narratives. And I only knew we were really starting to make progress when they weren't immediately able to answer my questions without thinking. So the longer they were thinking about their answer to a question I asked, and it was the first time I've noticed, but I really remember thinking, oh, okay, I can actually see them thinking differently now, because they don't have an answer immediately off the bat for that question. So that being comfortable with that silence and being willing to just sit there, let the parties think about what they really want to say, hopefully not having a lawyer coming in with their answer, to your question in the meantime can actually be really really useful. So it's a kind of a yeah, it's an interesting beast, or an interesting skill set, I think, your toolbox of questions that you bring, and something that really takes a long time to practice and to hone.
Yeah.
Aled, I'm going to ask you now to put up the video.
Okay.
And then I'm going to just introduce it and then rapidly mute myself because there's somebody driving by and the dog is about to start barking.
So who have we got in the expert corner today?
So who we have now is, and I referred to this earlier on, this is Professor Nadia Alexander, who is based in Singapore, very well-known mediation professional and academic and thinker and writer, and is even more of a regulatory nerd than I am, which is saying something. And in this, and we thought we wanted to leave you with this to just trigger some thinking about the whole question that is bearing down on the FJ in the UK around regulation of mediators and the mediation profession and who should do this. And the question that she is answering today is really sharing with us some thoughts on the value of regulating the mediation profession and why this may or may not be a good idea at all.
Oh, and just before I play the video, actually, it might be worth saying that Nadia is one of the faculty on the mediation law module on the LLM, and there is still a month to go if you are thinking about considering registering for the mediation and international commercial dispute resolution LLM with Newcastle University. It's fully online, and I think there may be a few scholarships still available.
There's a couple. We're just awarding them at the moment, but there's a couple left. Yeah.
Okay. Well,
over to Nadia.
Over to Nadia.
So if this is the case, that it's essentially unregulated, why bother doing training and submitting to regulation?
I think the answer to that question, first of all, is that mediation is not unregulated in that broader sense that we talked about, and it is a developing profession. Right? If you were to license mediators in the sense that no one could call themselves a mediator without having a license, it would be illegal. You couldn't hold yourself out to be a mediator. What would the consequences of that be now, right, in just about any country in the world? I think the consequence would be that many people who might mediate, let's say informally, school mediators, family mediators in the sense of the head of the family and extended families around the dinner table, they would be potentially in trouble, right? If there's a family feud and there's somebody, a head of the family, coming to try and help sort things out, and somebody then decides they don't like the way things are going, are they going to sue their uncle? My second illustration relates to the growing field of cross-border mediation. Right? As this profession develops, and it is really moving in the cross-border commercial and even investor-state field, people are wanting to use mediators more and more. Mediators are being held to standards, and if you look at the terms of the Singapore Convention on Mediation, you'll find that one of the reasons you might be able to challenge a mediated settlement agreement, right, is because your mediator hasn't conducted the mediation according to the applicable standards. So we are moving very quickly towards a professionalized world, right? But the risk is, if we move too quickly and license everybody, it has implications for people who are, I think, offering what I will call non-professional mediation services, informal mediation. It has severe repercussions for those. It also means that anybody who doesn't want to get accredited can just rename themselves and call themselves a conciliator or something else and still keep going on doing what they're doing. So, you know, taking this step-by-step approach and encouraging people to be credentialed, right, really extends the influence of regulation. in a way that wouldn't happen if you slapped down a law and said you can't call yourself a mediator unless you do X, Y, and Z.
Okay. There we have it.
There we have it. Food for thought. And actually, I was just thinking, Michael, we might need to do another great mediation debate, because this is a hot topic, I think, for debates in the mediation field, and is something that is, I mean, as Nadia says, is coming down the tracks much more quickly, because with developments in mediation such as those in the UK at the moment, by definition, it raises questions around the professional standards of the people who are delivering this service, and not least because of the necessity for users of the service to have a process to follow if things go wrong. So I think we might need to organise a great debate on that in due course in the near future.
Excellent, I think so. All right, well, we've run a little bit over this morning, and but I hope it hasn't inconvenienced any of you. In fact, hopefully it's motivated you all into some kind of action, whether that is thinking about the kind of questions that you're going to be asking today, being more curious about practice, law and regulation, or even just thinking about how you can make the world a better place than the one you woke up in this morning. Have an awesome day, everyone. Thank you for joining us.
Great week.
And we shall see you possibly next month for the next Spotlight on Mediation. Have a great day.
Take care, everybody.
Bye-bye.